So welcome, everyone. My name is Kim Moody. I am on the board of directors of NARPA, and I work at the P&A in Maine. And it is my great pleasure to introduce Susan Stefan and to be able to be part of hearing her again today. I think probably all of you on this call know that Susan is one of the top-notch mental health lawyers in the country, if not the premier. She doesn't want me to say that, but she's definitely nationally known as a scholar and a litigator on behalf of people with psychiatric labels, and has really dedicated her career to that. She has been all over the place, really molding the way mental health treatment is provided across this country, and has written a great deal, but her most recent book is Rational Suicide, Irrational Laws, examining current approaches to suicide in policy and law. And she came to Maine and spoke to us about that a couple of years ago, and just phenomenal. And so I couldn't wait to hear from her today. And so I think, Susan, without any further ado, if you would just speak to us, that would be wonderful.
Thank you. Thank you, Kim. When you say I've been molding mental health treatment across the country, I take no responsibility whatsoever for mental health treatment across the country. And I also thank you. I absolutely loathe doing Zoom presentations, and Kim taught me something that I haven't known in decades, which is being on the victim side of my particular advocacy style, which is to be incredibly nice, incredibly persistent, never go away. So I said to Kim, I don't do Zoom presentations, and here I am, and I'm glad to be here. And thank you, Kim, for she persisted, for persisting. And thank you to the Maine P&A for hosting me, and to Eric for holding my hand about Zoom presentations. And NARPA will be putting up both this webinar and the bibliography of everything I'm going to be referring to. I really was hesitant because all I've been doing is basically being a foot soldier during COVID in Massachusetts, doing commitment hearings and appeals hearings. So I finally agreed to talk a little bit about what I've seen from Massachusetts, but hopefully leaving enough time so that we can all share and brainstorm our experiences. Being in the middle of a pandemic is something that really gives you an appreciation for the importance of healthcare infrastructure. But even more, I think it gives you an appreciation for the importance of disability rights infrastructure. And here I am trying to actually change my slide, and it's not working, although it worked all the time in my practice session. There we go. So disability rights infrastructure, what do I mean about that? When I refer to disability rights infrastructure, I'm referring to having in place existing disability rights organizations that have worked together in the past, know each other, and can rapidly and cooperatively work with each other to proactively recognize what are the issues going to be in the pandemic, and to act immediately, because you can't have the usual kind of conference calls and committee meetings. A pandemic this is hard. It's hard to be proactive. None of us have ever lived through this. It was very hard on people individually. It was hard on people collectively. There is no playbook for this. And I'm very, very proud of the organizations, the disability rights organizations in Massachusetts that stepped up to the plate immediately. And I'm going to be talking today about 4 specific issues, not because they're the only disability rights pandemic issues, but because they're the ones that I was familiar with through my work and through working with the organizations in Massachusetts. These were the issues that I'm most familiar with. There's clearly other issues. The first one, I don't need to tell anybody that it was obvious from the beginning. I remember very early in March, just being very angry and crying at the very beginning of the pandemic, because I knew that, like, the people who were locked up were going to be at terrible risk and no one was going to be paying attention to them. I said the congregate facilities are going to be like charnel houses and nobody's going to be doing anything. And it was very scary, and it indeed came to pass to greater or lesser degrees, depending on who had advocates who acted swiftly and immediately, and we'll talk about that. Not only was there the risk of COVID, but the consequences of COVID were lockdowns in these congregate facilities, so that I don't think that it can be overestimated the harm and the damage that was done by bans on visitors, bans on people coming in. I had a client who was in a nursing home, and I was kind of startled because she was on hospice, and hospice quit coming. And I was thinking, if any organization is still going to be coming to visit their clients, it's got to be hospice. But no, hospice cut off their visits. So first of all, no visits. Second of all, to the extent that you think treatment helps, therapy helps, groups help, that was very, very drastically cut back in all of these facilities. And the psychiatric facilities were very much used to a particular routine or pattern for discharging people that involved discharging people on pass, seeing how they did. Well, there were no passes, and the fact there were no passes impacted greatly on discharges for discharge-ready people, because the congregate facilities were saying, we can't do our normal pass, our routine of seeing how people do on passes. Also, states either had in place or quickly developed triage standards to ration care with the anticipation that hospital systems and healthcare systems would break down. And that was something that was very scary, as you will see, given some of the state triage standards and their impacts on people with disabilities. Finally, the ban on visitation had a hugely disproportionate burden on people with disabilities. And I continue to believe that there are people who lost their lives because they didn't have people who could communicate on their behalf with hospital people. The hospitals were understandably in overdrive. They were in panic mode. They didn't have the time. They couldn't take the time to talk to people or communicate with people. And so for people with disabilities, denial of visitation could amount to a death sentence. So the organizations that I'm most familiar with, which is far from the only organizations in Massachusetts, but the people that the organizations I'm going to be talking about for the most part in this talk are CPCS, the Committee for Public Counsel Services, operates as the public defender in Massachusetts. It has a mental health litigation division that defends all civil commitments, all petitions for involuntary treatment, all guardianship petitions. The Disability Law Center, DLC, is the Massachusetts P&A. MHLAC is a specifically Massachusetts type organization where the state Supreme Court formed an agency to advise them about mental health issues. And that agency also now can do litigation and advocacy on its own and has done a wonderful job of doing that. The Center for Public Representation where I used to work. I loved that job, has done systemic advocacy for people with psychiatric and intellectual disabilities and brain injuries. And their website, I think, is a model for disability rights organizations' website. You can just tap right on something that says COVID-19, and it gives you really a pathway, a map to all the things that CPR has been doing and asking for people to do in terms of grassroots advocacy in both litigation and legislation. And the recovery learning communities in Massachusetts, also, I think, Massachusetts, idiosyncratic to Massachusetts, but very important, are state-funded, peer-run, peer-led organizations that have organized and really, really represent what peers want, especially the one in Western Massachusetts is particularly good, and I'll be talking a little bit about some of the work that they did. There's also a number of organizations like MAMH, the Massachusetts chapter of the Mental Health Association, PAL, which is Parents and Professionals Advocating for Kids, the Society for Prevention of Cruelty to Children, all sorts of other organizations. I'm not trying to say that Massachusetts is limited to these organizations, but I try and talk about what I know about, and what little I know is mostly around what these organizations did. Now, I'm just going to summarize very quickly and then go into much greater detail. The issue that people in congregate facilities were at greatly elevated risk of COVID, CPCS immediately filed litigation with the highest court in Massachusetts, the Supreme Judicial Court, asking for the discharge, the immediate discharge of nonviolent people who were at risk of getting COVID. And they filed two suits, one, and I'll explain why, one with the Chief Justice of the District Court and one with the Department of Corrections. And in Massachusetts, some people who are committed for treatment for substance abuse are under the jurisdiction of the Department of Corrections. So there was a civil commitment component to one of the lawsuits they filed, which succeeded in adding a new element to civil commitment cases, both new cases and also permitting a look back at the commitment cases of all people who were civilly committed. We'll talk about that. Disability Law Center investigated Tewksbury State Hospital, which was looking to be pretty bad in terms of staff and patient infections and deaths. And its investigation helped turn around the situation at Tewksbury with recommendations to better protect the people who were not getting out. MHLAC brought litigation against the Department of Mental Health over state hospitals that had high infection and death rates. The Center for Public Representation took the lead in challenging discriminatory triage standards, both in Massachusetts and around the country, in trying to get vaccine schedules expedited for people who were vulnerable, who had disabilities, in combating, unfortunately, I believe, failing to combat nursing home immunity. And there's a lot we could talk about nursing home immunity during COVID, and expediting home and community-based services funding so people could stay in their homes and not be put in congregate facilities, and fighting with Connecticut and other states policies that banned hospital visitors. The recovery learning communities provided reliable information about COVID, alternative services, remote services, and provided advocates with reliable information about what was going on in hospitals, although both CPCS and the Disability Law Center, and this is very important, had unquestioned access to the facilities. As long as anybody could go in, they were going in. They provided incredibly useful information about sources of vaccine hesitancy, particularly in populations of people with color. And they initiated a greatly needed public protest over hospital conditions at the Shattuck, which is a public health and mental health hospital in Massachusetts. So triage issues, I didn't know much about, but at the beginning of the pandemic, some of the state laws about triage, some of the state plans, they weren't mostly laws, they were mostly plans about what are we going to do if we start having to ration care. And for instance, in Alabama, the triage rules explicitly precluded ventilators for people with severe or profound intellectual disabilities, moderate or severe dementia, severe traumatic brain injury, including kids. In Tennessee, people with spinal muscular atrophy who needed assistance with their ADLs were going to be excluded from critical care. These were adopted, obviously in a room full of people who didn't include people with disabilities or their advocates. In New York, people who had ventilators that needed them for their chronic disabilities looked like those ventilators could be taken from those people based on an idea about who needed them more. Massachusetts had guidelines that, because we're Massachusetts, they weren't as terrible, they weren't as explicitly horrific, but they were based on long-term survival, which is discriminatory against people with disabilities. Those were changed to short-term survival. And in Washington, there was guidance to transfer people with loss of reserves in energy, physical ability, cognition, and general health to just get palliative care. So one of the things about triage, I love John Callahan. This is a John Callahan cartoon. It says, "This town ain't accessible enough for both of us." Is people with disabilities end up sort of being pitted against each other for needed care. And we can't have that. And I'm proud of the way that the disability communities work together in the pandemic. So I want to briefly go through a timeline. I'm going to look and see what questions there are. See if there seems to be a question. Let's see here. What are ADLs? ADLs are activities of daily living. So activities of daily living are being able to get up, being able to go to the bathroom, being able to take a shower, being able to feed yourself. So if you need assistance with ADLs, that is a very, very common kind of metric of assessment of disability, vulnerability, need for supportive care. Do you need help with your ADLs? I'm sorry. And please, anybody, I'm going to be keeping an eye. The Q&A box is nicely near the little lens of the camera that I'm looking into. So if anybody has any questions, I'll be able to see it in the Q&A box. The timeline, I want to give you a timeline because when I talked about immediate response to the pandemic, this will give you an idea of just how much was happening, how fast. And just to give you a little summary right now, when CPCS filed its first lawsuit with the Supreme Judicial Court, I don't know how many of you are lawyers, but between the filing of the complaint and the decision by the Supreme Judicial Court was 9 days. All the briefing, all the argument, 9 days. Between the time that CPR and the Alabama P&A filed their complaint about the Alabama triage system and it was resolved was 15 days, just over 2 weeks. So things were happening very, very fast. Were the various advocacy strategies coordinated beforehand? Did each agency react individually? Was there a specific press strategy to raise awareness and build CYA, which I only know as cover your ass, among lawmakers and judges? So I believe that the various agencies got together fast. Each of them were doing what they individually could do. So CPCS, as the representative of people who were in jails, in prisons, who represented people in mental hospitals, CPCS was able to bring a lawsuit in its own name, although it brought that lawsuit with the help of the ACLU and the Massachusetts Association of Criminal Defense Lawyers. So I think there was a lot of coordination around things like challenging the state triage policies. And both the Bazelon Center, CPR helped various states do that. And there was also coordination, both interstate and intrastate. On March 10th, our governor declared a pandemic emergency. By March 12th, visitation was restricted at nursing homes. This was a hugely damaging, harmful thing to the people in the nursing homes. And I had a client who died not of COVID, but I'm convinced died because of COVID as opposed to died of COVID, who was in a nursing home. By March 19th, visitors were restricted from state psychiatric and other health facilities, although lawyers were still allowed in and went in. March 21st, less than 2 weeks after the declaration of the pandemic emergency, the first COVID positive prisoner was identified publicly, of course, as opposed to, I'm 100% sure there were COVID positive prisoners well before that. March 23, CPR files a triage complaint in Washington. The 24th, it files a complaint in Alabama. 25th, 2 weeks after the emergency is declared, CPCS, the ACLU, and the Massachusetts Association of Criminal Defense Lawyers file a huge systemic complaint on behalf of all people incarcerated and being held for bailable offenses, for probation violations, incarcerated everybody in Massachusetts prisons and jails to be released, to be discharged because of the danger of COVID. And I'll say right now, what the Supreme Judicial Court said was, look, we have no jurisdiction over people who have been sentenced because they're under the Department of Corrections. But the courts do have jurisdiction over people who are being held. Bail is a court function. Probation violation is a court function. So once again, I'm having trouble moving my slides here. March 26th, the CPR and PNA and MHLAC, so that's an answer in part to one of the questions about coordination. The disability advocacy groups write a letter to Governor Baker saying the current triage guidelines are discriminatory. Here are our proposed guidelines. And especially in an emergency like the pandemic, you can't just be a critic. You've got to have a solution. So you write the letter, and the letter says, your current guidelines are discriminatory. Here is exactly what you need to have, and we will be satisfied with this, and we've done the work for you. And here are the triage guidelines. And as I said before, I'm going to have a bibliography that will connect you to all of these letters, the complaint in CPCS versus Chief Judge of the Trial Court. March 27th, CPR files another complaint about Kansas triage, the Kansas toolkit for COVID-19. By March 28th, HHS has issued its first federal government triage policy. So meanwhile, the Bazelon Center, CPR, are talking with the federal government about federal triage guidelines. March 31st is the oral argument, in this case, scheduled less than a week after the complaint was filed. April 3rd, 4 days after the oral argument, the Supreme Judicial Court says, look, we can't give you relief about prisoners, but we will order that nonviolent pretrial detainees are entitled to a rebuttable presumption of relief. Now, that doesn't mean everybody goes. Everybody's lawyer has to file something because a rebuttable presumption can be rebutted. So everyone who's being held for a non-index, there was a list of offenses that you could not be released for, but mostly people could be released if they were being held on bail, but their lawyers had to file for that. April 16th, joint letter from the PNA and MHLAC about conditions at the Shattuck. same day that 67 patients and 46 staff tested positive at Tewksbury Hospital. You got to realize that just getting testing into congregate facilities was hugely problematic. Getting protective equipment into congregate facilities was hugely problematic. Nursing homes got protective equipment after hospitals did, even though the nursing home population was incredibly vulnerable. By April 21st, the first psychiatric patient died at Shattuck Hospital from COVID. And less than a week later, 3 days later, DLC, the P&A, initiates an investigation of how COVID is being handled at Tewksbury State Hospital. May 3rd, the Center for Public Representation and the P&A file a complaint about hospital visitor policy, not DRC, I strike that, I apologize. That's Disability Rights Connecticut. So CPR works with Connecticut to start getting at bans on visitors in hospitals, which are acutely damaging people who have communication disorders, people on the spectrum, people with intellectual disabilities, many people with psych disabilities. So they worked out a way to accommodate those disabilities and permit visitors. By May 7th, the foster complaint is filed. The foster complaint is incredibly important. So that's when CPCS takes the first case and says, okay, the trial court, the Supreme Judicial Court does not have discretion to modify or discharge prisoners who have already been sentenced or people who have been committed. So they filed Foster versus the Commissioner of the Department of Corrections is filed, and it includes people who have been committed for substance abuse. All of this has happened in less than 2 months after the pandemic by entities that had to initiate their own pandemic precautions, take care of their own staff, adapt to technologies, different technologies. So, you know, people who had families to worry about, families to protect, these entities, I think, stepped up to the plate and did it fast. Here's a question. Have you addressed the challenge in organizational behavior by government entities, financial entities, the research entities such as the Broad Institute at MIT? When I was visiting with my urologist early in COVID, I would ask about COVID, and his response was, that is what flu shots are for. So part of your work is that of trying to realize better flexibility to the structure by which knowledge is being created within the law. But what about any future pathogens that can be transmitted at these speeds unheard of to date? What I said at the beginning of the talk and what I said to Kim when I was trying to weasel out of this talk is, I don't know a lot, and I try to limit what I'm talking about to things that I know pretty well. I'm not saying those aren't great questions, but they are above my pay grade or outside my area of expertise. I think the question about better flexibility to the structure by which knowledge is being created within the law is a really good question, because the law has to move much, much faster and be much more adaptable. And I think in this case, I was surprised and pleased by the degree of flexibility that Supreme Courts, we'll talk a little bit about that later, showed, and courts showed in general. The problem, there were problems with lower courts. Again, more to come. Okay. May 7th, SAMHSA issues consideration for care and treatment of substance abuse and mental disorders in the COVID-19 epidemic. Sorry about my phone. Lots to dislike, some stuff to like about that policy. You obviously need to have that policy. They reiterate that anything that can be treated in the community should be treated in the community. They didn't go as far as I think they could have and should have gone, but mind you, this is 2020. This is May 7th, 2020. We're talking about the Trump administration SAMHSA. In that context, I think it was pretty good. May 17th, peers start protesting at Shattuck Hospital over the terrible treatment and the risks that people were being subjected to by continuing to be institutionalized. By June 2nd, the Supreme Judicial Court decides Foster. And the Foster case, which I'll include in my bibliography, is well worth reading because it really, for the first time in decades, takes a look at why do we have civil commitment in the first place? What are the state interests? What are the liberty interests? And it really kind of, even though they said nobody is challenging the commitment statute here, they look at the kind of risk alleged benefit ratio and they say, look, if you want to like save people from risks to themselves by jamming them in congregate facilities where they're not getting any treatment, they said, the constitutional permission for civil commitment wears thin during a pandemic of contagious and lethal proportions. And we're willing to relook at that. And they did. We'll talk a little bit about that later. On July 31st, 2020, MHLAC sues the Department of Mental Health, the Massachusetts Department of Mental Health, over conditions at Tewksbury State Hospital. I just want to make it clear, it's not like Massachusetts is prancing around and nobody else is doing anything. Alabama worked with the Bazelon Center and CPR and was among the first states. The Alabama P&A complained about discriminatory triage standards, which in Alabama is substantively really important. So in Massachusetts, it's good to make sure the triage standards weren't discriminatory, but in fact, the healthcare system never ripped apart. But if you are an advocate or a P&A in a deep South state or in Idaho or South Dakota or Wyoming, you should be looking at the triage standards because the notion that your hospitals are going to be able to withstand the COVID pandemic created by the unvaccinated people, that's still up in the air. The triage standards matter very much in states where the healthcare fabric is at risk. In California, the P&A sued Patton State Hospital in August of 2020. CLRP asked on April 20th, right after the pandemic started, asked for bans on psychiatric hospital admissions and expedited discharges. By April 3rd, by the time of the CPCS versus trial judge decision, they were able to cite to what had happened in 4 other states. Michigan, the Chief Justice said to the judges, you got to release more people on their own recognizance. You've got to use more probation and treatment programs as alternatives to incarceration. That was prior to April 3rd. New Jersey, the Office of the Public Defender got a consent decree that suspended the sentence or commuted the sentence of low-risk inmates. South Carolina, the judiciary in South Carolina, as far as I could tell, sua sponte, but I could be wrong, and I'm hoping that people on this call can, jump in when I'm done and correct me and we can brainstorm. All non-capital defendants shall be released on their own recognizance without surety unless they present an unreasonable danger to community or extreme flight risk. Like South Carolina is doing that and doing that by April 3rd. So I'm going to talk a little bit about Foster versus the Department of Corrections. So as I said, it involved all incarcerated prisoners and all people committed for substance abuse. But the language of the decision, and one of the things that the Supreme Judicial Court was good about here in Massachusetts, was extending and expanding their decisions. So they would say, they said in Foster, for instance, even though nobody raised this thing about elements of the commitment standards, like we're going to use our powers of superintendents. And if you've got a good state Supreme Court, powers of superintendents is a phrase you want to know and use, because the Supreme Judicial Court used their power of superintendents a lot to do some good things. They said, we are going to look at the commitments, how people end up committed. And they said, commitment always must be narrowly tailored to meet the government interests in safety and treatment. And a pandemic affects whether that remains true. And therefore, for the duration of the pandemic, which is now over, Governor Baker has ended the state of emergency, the Supreme Judicial Court added an element to the criteria for commitment. It actually added 2 elements. The court, before it committed a person, was required to weigh the danger posed by the individual's substance abuse disorder and the risks that flowed from that, the substantial risks that were a result of the substance abuse disorder, with the risk of transmission of COVID-19 in congregate settings. So one reason that is really important, and now I can speak from firsthand experience representing people in psych facilities during the pandemic, is you couldn't wedge out the most basic information from those hospitals. I'm not talking about HIPAA protected information about individuals. I'm going in to a hospital to see my client. I want to go in, but I have, an immunosuppressed husband, and it would be really helpful for me to know, are there COVID positive people in the hospital, on the ward, among the staff, among the patients? I don't have to know who they are, but it would be nice for me to know the COVID status. And P.S., my client is an older guy. He has diabetes. He's overweight. I need to know what risk he's at. And it was really hard. One of the successful wars was to get the Commonwealth to publish information. A state representative had to file a bill to even find out how many people had died in nursing homes, how many people were infected in nursing homes. So no commitment unless the risk outweighs the risk of transmission of COVID, for which you have to have information not only about COVID in the community, COVID among the staff, COVID of the clients. Additionally, the commitment must be necessary even taking into account treatment limitations. So one of the things that I'm very proud the CPCS Mental Health Litigation Division attorneys did was find out, like, just how much quote unquote therapy or treatment is my client actually getting? Because the group therapies, they shut down. The exercise in the gym, forget it. There were lockdowns even when it was known that getting outside was safer. Some people essentially spent weeks in basically ad-seg, segregated in their rooms. And these are people with serious psychiatric disabilities. So the Supreme Judicial Court made clear in Foster that you're locking people up in part because you're saying they need treatment. And you got to be able to prove to us that the amount of treatment they're getting makes taking away their liberty worthwhile as a constitutional matter. Now, this applied not only to new commitments, it applied people who had been committed could ask for their cases to be reopened and re-examined. All right. Now I want to talk a little bit about the downside. I think these were incredible victories, and I'm just honoring and respecting the people who worked their butts off to get these victories. But like all Supreme Court victories, things have to be implemented at the ground level. So the SJC ordered that non-dangerous people should be discharged. And this met, and again, this is something I can talk about firsthand, this met with tremendous resistance from district court judges and DAs. So there were people who were obviously nonviolent, and there were DAs who were filing oppositions. So what you had to do was the person's lawyer had to file a motion for pretrial release, and the DA could only oppose if they said the person presented an unreasonable risk of danger or flight. And there were some DAs that were doing that for everyone and there were some district court judges who were saying, no way, somebody does something bad. The headline in the local Worcester Telegram is not going to be SJC issued order to release non-dangerous people. Most people were non-dangerous, but there was one who was dangerous. It's going to say my name released that person. So the implementation on the ground by the people who are in charge of letting these non-dangerous, non-violent people go, left a lot to be desired. And one of the things that I will say as a recommendation at the end of this talk is we have, as a disability community, we have got to pay a lot more attention to who the DAs are. DAs are elected, and nobody pays that much attention to who the DAs are. But there were two quite progressive DAs in Massachusetts, and their people in jails in their areas got let out because their DAs got the message not to oppose. Rachel Rollins is one of them. She's now been nominated by Joe Biden to be the US Attorney for Massachusetts. Triage victories, the principle of the victory is very important because people look to these guidances. But the triage victories, if the person was unaccompanied, had nobody to advocate for them or communicate on their behalf, that was a real problem in implementation, making the fight to ensure not just visitation, but accompaniment for people with serious intellectual disabilities or brain injury or on the spectrum. That was really important. And also, ventilators are scarce, but ECMOs, and that is, before I get another Q&A about unfamiliar acronyms, I don't even know, like I had it written down in my notes. My notes are here somewhere. But what it is it's a machine that takes your blood out of you, takes out the carbon dioxide, shoves in a lot of oxygen, and sends it back through. It basically takes the place of a lot of the work that your heart and lungs do in making sure you have enough oxygen. And those machines are even more scarce than ventilators. And another lesson of the pandemic is, if a resource is scarce enough that it's scarce for non-disabled people as well as disabled people, I don't know what we're going to do about that issue. So lessons learned for the next time. Get your disability rights infrastructure in place. Get organizations meeting together routinely, working together. Do you know who does civil commitments in your state? There are various models of how people subject to civil commitment are represented. And there's bad ones and good ones. And in my opinion, the very best one, the only one where there is much of a hope of effective assistance of counsel, is an entity that is staffed by people who focus entirely on civil commitments. So in Massachusetts, there is CPCS is a huge public defender's office, but it has a mental health litigation division. And that division does nothing but commitments, involuntary medication petitions, guardianships. Same thing in New York. The Mental Hygiene Legal Service in New York City does nothing but representing people in commitment hearings. In Miami-Dade, as opposed to the rest of Florida, they had a mental health unit that did nothing but commitments. In Minnesota, in the District of Columbia, it's like Massachusetts. Within a very good public defender's office, there is a permanent mental health litigation division. Same thing in Minnesota. And that allows you to train people, have them have experience, have them keep up with the particular law, become immune to a lot of the mythology about how we're just here to help people. So working on getting in place a permanent entity of experienced people who care about clients in mental institutions, who can ally themselves with and work with the P&A, that I think is a really good idea. And the P&As should work regularly with, there's tons of these organizations, ACLU, Legal Aid, Legal Services, Public Defenders. How to distinguish between quantitative risks as opposed to qualitative risks in decision-making process of the organization and the individual. To what extent was an economy being created that could absorb those released, not just in holding, but then what roles could be realized to move towards the individual hopes and dreams? So I think I understand this question, and if I don't, Bill Wells can correct me and respond. What I would say is, in the moment of the pandemic, people's hopes and dreams, as opposed to getting them out of a place that could kill them. So we were really focused on trying to keep people alive there, and that, it didn't work a lot in nursing homes, because nursing homes did not have a disability rights, they didn't have much of an infrastructure. The families weren't particularly organized. The people were, many of the people might have been too fragile to go home. I don't know, because I don't know a lot about nursing homes. But the people who died, there was at one point in the pandemic, and I don't know if this is still true, but at one point, 60% of the deaths in Massachusetts were from nursing homes. And there were 36,000 people in nursing homes and 970,000 other people in Massachusetts. So for 60% of the deaths to be absorbed by nursing homes, honestly, I think that now that time is passing, individual hopes and dreams, yes, but you got to get people out so that they can live. You can't get them out. One of the things that was argued, and this is something else I want to bring up, the hospitals used the risk argument to keep people in. So I had a client who spat a lot. He, was not particularly dangerous to others or to himself. And the behavior of spitting would not have been front and center in his civil commitment hearing, but for the pandemic. So it's not only that you have, diabetes, or you're elderly, or you have multiple medical conditions, you're at risk of getting COVID, you're in a congregate setting, but there were occasions where COVID was used as a sword to try and keep people in hospitals because their risk would be greater in the community. Michelle says, Susan, one way to turbocharge your lesson 2 is for you to offer this training at NLADA conference, substantive training conference, November 2021. Like, unless NLADA is run by Kim Moody, if it's run on Zoom, I love NARPA. I will do things for Kim Moody and NARPA. I would love to do this training. I miss the in-person energy of NARPA very much. But I do think, and this is one of the things, train the trainer. I'm trying to get the message out to you guys. is if your P&A is not sitting down on a regular routine basis with other organizations that defend and represent oppressed populations, people who are going to be thrown under the bus in the next pandemic, or who are continuing to be thrown under the bus now, you're not going to have the disability rights infrastructure that is necessary to save people's lives. Another thing, make sure you now know what your state's triage guidelines are, fix discriminatory provisions now. And I have gotten extremely evangelical about knowing who district attorneys are, electing progressive district attorneys, having a progressive district attorney. If you elect your trial court judges, finding out who does your civil commitment hearings, and not just trying to educate judges who do civil commitment hearings, because the older I get, the more I'm disillusioned about training people and more inclined to say, just like, get those people out and put in people who already get it, who already know, who don't have to be trained. So I think paying more attention to really community level politics. If your issue is, I don't know very much about kids with disabilities in schools, for God's sake, look and see who is on the school board and get those people elected. So the bottom line, things need to be done now. What are we working on now? There were many civil rights that were relaxed in ways that you really could not oppose during the worst of the pandemic, like my nemesis, Zoom commitment hearings. And the judges love the Zoom commitment hearings. And in our state, which is relatively progressive, we are fighting tooth and nail. It's almost, it reminds me of the Civil War in some ways. It's like, one trench at a time, trying to get hearings back kind of person to person and out of Zoom. My stepdaughter does fabulous work with supervising people who do in-home therapy for kids. And a lot of the people, the social workers she works with, they don't want to go back to in-home because that means like driving 60 miles, driving 70 miles, and Zoom is much more convenient. So I think getting back safely and quickly to in-person is kind of the fight of the moment. And in big picture terms, a goal, to have a world where all of the disability rights organizations don't have to go into overdrive within 3 weeks of a pandemic being declared, because policymakers and decision makers automatically think about people with disabilities when making policies. We don't have that. We don't have that right now. So what we have is people who misunderstand what people with disabilities need. And I am very, very glad these fabulous cartoons are by John Callahan. And I have a question in the Q&A box, which I will take and be glad to open it up for questions, comments. Bill Wells says, I agree, crisis management that did not know how to work through case-by-case fear was beginning to drive the thought process. The moving of the balances with more scales is difficult. Yeah, there was a lot of fear going on, even among lawyers. So to be fair, I got into fights with lawyers that didn't want to go visit clients in person. And it's not that they were, totally unreasonable. These were older lawyers. These were lawyers with medical problems my thinking is, like, if you've got a client, you've got a client, and you do 100%. And I was the last person out when they closed down visitation by everybody, and actually the very first person in when they reopened visitation. And that, I'm proud of that. That matters to me, because you can't be asking systems to make sacrifices or do extraordinary things if you yourself aren't there saying, look, yeah, I have a husband who has immunocompromised, but I need to see my clients in person. You need to be letting people in. So any other questions, comments, discussion? I'm assuming everything is in Q&A and not chat. Until we get to nirvana and have all decision makers be people who get it, what can P&As do today to get out of their silos, tempt legal aid and public defender staff to also get out of their silos? Massachusetts was already more or less networked, and there were a lot of antecedents to that. And when I talk about allies, let me be clear, to make the allies as broad as possible. The Center for Public Representation and also the Disability Law Center in Massachusetts make it a practice to involve large budget law firms in many of their systemic cases. I know that's not foreign to a lot of you. There was one systemic case where the law firm had better IT than the state agency that was being sued. So using resource-rich entities like law firms, Paul Weiss in New York is absolutely fantastic, but every state will have them. And what you do, the thing that I think needs to happen is, in Massachusetts, there is a consortium of disability organizations, and they meet on a regular basis. So they meet to coordinate their response to bills that are in the legislature, to introduce bills that are in the legislature. Every organization kicks in a little bit of money, and they have a full-time lobbyist for people with disabilities in the legislature. They may have two by now, but back in the day, when I was working, they had one who was really good. And I know in DC, there's similar practice to have people meet and send, not just their summer interns, but send the heads of, like, the people who run litigation, people who are decision makers, to regular meetings. So they get to know each other. They know what each of them know what the organization is doing. They know who people are. They're friends. They understand each other. I think that that's really important. And I don't think it is that difficult. I think one way to do it is to look at what you have to offer them. So, for instance, one of the things we don't do well enough, one of my things that I think really needs to happen is the Mental Health Litigation Division in CPCS does its own thing, and the criminal people do their own thing. And we often have the same clients. So there'll be a client who has a criminal defense attorney and a commitment attorney. And yes, those attorneys talk to each other, but there isn't that kind of routine meeting and getting to know each other. And what we have to offer is knowledge and information about how the mental health system works for the criminal defense attorneys. They can teach us more about the judges, various kind of cultural things about the criminal justice system. So figure out what you have to offer each other. So it's not like they're doing you a favor by showing up. Phil Castle, yay, Phil Castle, MHLAC. In mounting our unsuccessful effort to force the Massachusetts Department of Mental Health to discharge people suffering needlessly during the pandemic, we supported our motion for preliminary judgment with 4 expert affidavits that allowed us to make the case that confinement for mental health treatment is ineffective even under normal circumstances, never mind during a pandemic. This could be useful in other political, legal, policy, advocacy contexts. If interested in getting these, ask me at capital P, Castle at MHLAC. I assume all of you can see this. Phil, if you can send it to me also, I'll make sure it's in my bibliography of materials. I think that the Foster case opens the door in Massachusetts also to looking at the efficacy of treatment in individual cases. There are so many people who are locked up who are getting same as usual, when it is obviously not helping them, maybe giving them diabetes because of the Zyprexa, they're gaining weight. And I think that level of analysis about how narrowly tailored civil commitment has to be, both in terms of risk and the benefits derived by treatment, I think we might be able to use that with receptive judges. Did anybody try to get support from the Leadership Conference on Civil Rights, the biggest coalition of civil rights nonprofits? I'll bet for sure that Bazelon and the Center for Public Representation did what I was talking about. The title of my talk is What Happened in Massachusetts. There were a lot of national organizations, the ACLU, the Bazelon Center, doing a lot of national stuff. And that's not, I don't have the expertise to actually talk about that. Eric Rosenthal says, United Nations Committee on the Rights of Persons with Disabilities is now drafting international standards on the protection of institutionalized people with disabilities and the promotion of the right to community integration in the context of public health emergencies. If you or others on this call are interested in work on these standards or sharing other positive models, please let me know. I think standards in the context of public health emergencies is the way to wedge in international standards, because as I have said to Eric over and over again, over decades of time, I don't think US courts are really interested in whatsoever what international standards are or what other countries are doing. But when it's a pandemic, everybody is looking around frantically for guidance. What on earth are other people doing? What is already written down on paper? So I think that standards for the protection of institutionalized people with disabilities in the context of public health emergencies might be very helpful. Phil says, we focused on Foster, argued we filled in the gaps that plaintiffs in that case did not, but we still lost. Phil, if you can write a little bit more, or I don't know how to, I wish I could share. See, this is where me not knowing Zoom, I'd love to be able to share the screen with you, but if you can say why you think you lost, that would be helpful. The bibliography will be available. I'm going to put it together over the next few days and send it to Kim and Tom, and they will put it up on the NARPA website. Okay, I think, have I caught up with the questions? I don't know, Kim or Eric, if there is a way to.
I think I just unmuted Phil. I hope I did.
Phil?
You did. I wasn't. I stuck my foot in my mouth here in the hopes that, without intending to actually present on this, it's a way for me in my memory. But I will say that there was undue reliance on the Youngberg v. Romeo standard as the legal basis. And other than that, the pandemic had kind of died down by the time the case got before the court. We argued that the court nonetheless should take action because the pandemic would heat up again during the fall and winter, which in fact it did, but not to such an extent, or the prediction wasn't as clear to get a court to do something it hates to do, which is to tell a state agency to do something it doesn't want to do. So I'd say, the main problem we had was political, question of timing, and the legal analysis. We thought it kind of sucked, but we didn't think we would do better, particularly given how Foster had worked out, which was filed by Prisoners Legal Services, by the way. And so we didn't take an appeal. We did initiate a settlement, which we saved a little face by getting some documents, in report and a reporting requirement. But we made an effort. It was valiant. We lost, is what it comes down to.
I also think that it's tremendously important to get in the press. One of the things that what you did was a success, not only in getting the documents, but the press covered this case. It covered the arguments. It brought to the attention of the public that there are people locked up in mental institutions who can't get out, with staff who are coming in and out every day with COVID infections, wearing or not wearing masks. And to get that information before the public, I think was very, very important. And filing the lawsuit was a vehicle to educate the public about the dangers, not only like the nursing homes, I think the public had figured out, but I don't think people think about people in psych institutions unless there are newspaper articles and litigation. And we thank you and honor you and respect your work for that. And thank you very much.
Thank you.
So I don't know how much time I have left. There are a couple more questions, but if the NLADA wants this webinar, absolutely, they can have it. I have no intellectual property interest in this webinar, and I will make sure that there is an accompanying bibliography of the materials that I've spoken about. Yeah, the press loves things like litigation and protests. One of the reasons the protest was important. So, if you get 25 people yelling with signs who are very highly informed about what's going on, you can educate the public through the press in a way that is much better in terms of public education than testifying before the legislature. In terms of bringing design into the law, I think we're at a nirvana level in this discussion. I mean, one of the things that is always a tension is there's a tension between like the day-to-day, getting individuals out, doing appeals for individuals, and the whole system that is throwing people into the river upstream. And one of the things that I think is really great is Phil's having experts say, I was thinking about this myself. It's like, why do we still think that institutions are helpful to people? Why? And I was just looking today, Tewksbury State Hospital that killed some people during the pandemic. It's $330,000 per patient per year. I mean, what could you do with $330,000 to help somebody? And I do think that maybe pandemics are paradigm-shattering events that may allow people to step back and say, for example, at the beginning of the pandemic, when everybody was scared to go to the emergency department, nobody with psych disabilities was being brought to emergency departments for suicidality or psych emergencies. It just plummeted. And it's not like the overall suicide rate went up. Commitments, there were weeks when the petitions for commitments were down by 50%. And it's not like the Commonwealth broke apart. And people were being let out of prison on bail, or not on bail, but nonviolent offenders who were being held were being discharged. And it's not like the crime rate went up. So why are we doing these things? I think it's time to exploit the positive side of the paradigm shifts in the pandemic while making sure the negative parts, which is over-reliance on Zoom meetings, like just goes. So thank you very, very much. Thank you for all your questions. Thank you for coming. And thank you, Kim.
Well, thank you very much. It was excellent, of course, and a pleasure to see you. And thanks for everyone who participated.
Thank you. Thank you all.
Bye-bye. Bye, Susan.
Bye.